Hi everybody, welcome back to my channel, Law Hero, and today we have the joy of discussing equity, and you might be able to tell from my humour that equity is not my favourite subject. Okay, so I'm going to use the March 2019 paper as the guinea pig for going through the exam. So question 1 is a problem question on trustee duties. Some young fella has a trust set up for him and the trustees go AWOL. What is his recourse as a beneficiary? So the trustees, they're the legal owners, but the beneficiary is the beneficial owner. It's important that they're the legal owners so that they can deal the property, that they can invest the property so that there is an income for the beneficiary down the line when the trust is discharged. But you also have to know other things about the trust deed or statute which regulates how the trust is actually managed. And if you don't know that, how are you supposed to advise trustees? So there's an 1893 Act, should have been reformed, they didn't do it. Law Reform Commission were like, reform the Act, and they never did it. The other thing as well is the trust deed might give the powers. It depends. So you have a trust deed, right? That might just say you follow the 1893 Act and then off you go, Bob's your uncle, you follow the 1893 Act. Or the trust deed might be prescriptive, as in it'll tell you exactly what you're supposed to do as a trustee. So normally you can get a court order against your trustees if they've run amok, and you can set out all the different causes of action, as in they misplaced the money, they didn't invest it properly, they're in breach of, so fundamentally they're in breach of trust, right, obviously, that they have what their duties are, they have a duty to safeguard the assets, conflict of interest, all those kind of things. So you go down through those, and then the investments as well that they're allowed to invest in. Is an essay on undue influence, and so the examiner is sick of people getting this wrong because it's so simple. It really is so simple. What you have to understand about undue influence is, in certain relationships, there is a presumption of undue influence, okay? And it is for the person whom the presumption is being made against to discharge or rebut the presumption. Actual undue influence is really difficult to prove because humans are clever and we act covertly as opposed to overtly. And if you actually unduly influence someone, that is like threatening someone, like you actually say, I'm going to break up this relationship if you don't do this, or I'm going to set fire to the house if you don't do this. It's almost like duress. And back in the day, in like the BCCI case, there was this phrase, manifest disadvantage. Again, that's difficult to prove, so the courts have kind of shied away from that. Injunctions. I actually love injunctions because that is question 3. And I'm not going to go through it, but it's a Quia Timet injunction. And Quia Timet means just in time. It means you don't have time to be waiting for your cause of action to go to trial. It needs to be done now because things are bad. So like here, for example, this guy's really afraid that his livelihood is going to be taken away. Like, that's a big deal. So don't forget though, when you're answering the question, set out which injunction you're going to use. Like, don't just dive in and be like, oh. No, you have to go, this is the injunction I'm going to use. The other thing I've written down here is set out the standard of proof, because it depends on whichever injunction it is. And then you have to explain, okay, if it's an interlocutory injunction, the campus oil principles are going to play into that. If you want to preserve the status quo, you need to get an interlocutory injunction, which means that will preserve the status quo until the full hearing of the trial, okay? And if it's interlocutory, that should be ringing campus oil principles in your head. I love these things. I think they're cool. So basically, if I am a solicitor and I'm advising my client who is a trustee, as in I'm advising them on their role as a trustee, and I know that whatever actions that they're doing are in breach of the trust, that puts me on notice that they're breaching the trust, but that makes me a constructive trustee. So the locus classicus, or the very first kind of positive statement about constructive trusts and the kind of threshold for people who are advising trustees, was as follows. And it was held that strangers are not to be made constructive trustees unless they assist with knowledge in a dishonest and fraudulent design on the part of the trustee. The breach of trust is always a prerequisite of constructive trusteeship, and that being a cause of action. So there are like two pillars of litigation. So we'll say if I'm the beneficiary and I want to get at the people who caused my misery, I'm going to first of all go for the trustee, because that's my like first port of call. You breach the trust, I'm going to come after you. Okay? Court order, whole lot, you're in trouble. But what if that guy was being advised by someone else and his defense was, oh, poor me, my advisor told me to do that? Then you have to go after the advisor, who is the solicitor or investment advisor, or who knows. And then you have two pillars of litigation, but obviously if you have two pillars, they need to be proved on their merits. And for the one we're talking about, constructive trusteeship, that is difficult to prove because of this knowing assistance, which has led to dishonesty. Question 5 is a lovely question on donatio mortis causa, which means a gift in contemplation of death. And Valet v. Birchwood is a really good case to prove your point, and Sen v. Headley was quoted in that case. Sen v. Headley is the test. You have contemplated your debt, and you have given dominion of whatever, the keys to the box or the deeds to the house over, but you're not necessarily expecting to die, if you get me. So it's kind of, there's a difference. And, you know, the Valley v. Birchwood case is a very good example of that. You know, because you know, it was obviously the summertime when this adoptive daughter visited her dad, and he was like, look, I probably won't be around by Christmas time. And he died a little bit after that. And you know, like, that's pretty strong indicator that he contemplated death in giving her the gift, but he didn't necessarily expect to die exactly at Christmas the way he predicted. See it like that. So question 6 is the notes question. I'm not necessarily going to go through that because that changes every year, but it's normally just some kind of trust law. It could be specific performance as well. You can avoid that question if you want. It's more kind of just a handy backup question if everything's going wrong for you. With specific performance, you might have some level of hardship, which means that were they to enforce the contract, that it would be difficult for it would cause trouble, basically. And they kind of have to look at the balance. And, you know, like, people always say, oh, there's no specific performance for contracts for services, but the courts have said that's not true. They'll always just look at the circumstances. So yeah, I mean, when you are looking at the likelihood of specific performance, you have to really look at the facts. So, you know, this one is going to be quite fact heavy as a problem question. And then the last question is resulting trusts and advancement. This normally comes up with joint accounts, for example. So you have to look at, you know, who was in charge of the joint account during the lifetime? Did they have any role to play in depositing funds, withdrawing funds? The other thing as well is, like, you know, the courts will not advance funds for an illegal or fraudulent purpose. I really hope you enjoyed this video. I couldn't even say that with a straight face. I'm just not down with equity. I find it miserable. At the same time though, imagine if you needed it someday. You know, you'd be happy you learned it. So yeah, like, please like and subscribe. We will get through this together. Thank you so much for watching. Namaste. Don't know why I did that, but thanks.